We shall start the webinar. The topic of the webinar is the Maintenance and the Welfare of Parents and Senior Citizens Act of 2007. As you all know, this is one of the major acts which was introduced in the year 2007. So the objective of this act was to make effective provisions for the maintenance and welfare of the parents and senior citizens, which are guaranteed under the Indian Constitution. Okay, so the major misconception related to this act is it is only for the senior citizens. No, it includes even parents who are not the senior citizens, and that is who are not above the age of the 60. This enactment got its assent on 29 December of 2007. So basically, this act has 7 chapters and 32 sections. To start with, first we will look into the definition part. The definition is covered under section 2. There are 6 definitions, 6 terms which are very important to understand the provisions of this enactment. The first one is children. So under children, son, daughter, grandson and granddaughter. These 4 persons are covered under the category of children. So when a senior citizen or when a parent is claiming his property or he is not being treated good, then the act, when it says that the children are liable to it, it includes son, daughter, grandson and granddaughter. The next point, parent. So parent here includes biological parents, adoptive parents, stepfather or mother. And to be covered under the definition of the parent, the person need not to be a senior citizen. A parent may be any person who is aged like 45, 50 or any age. So that is not age is not a criteria to be considered as a parent under this act. Property. So whenever this act makes reference to the property includes all kind of movable, immovable, tangible, intangible, self-acquired and ancestral property. Yes, the person, if the section 23 of the act says that the property transfer can be made void, it even includes the ancestral property, not just the self-acquired property. Next, we will come to relative. The term relative in this act is used for childless couples. If there is a parent, if there is a couple and they are childless, their property will go to a legal heir. And that legal heir is considered as the relative. So it reads as the major legal heir of the childless senior citizen who will inherit his property. So whoever inherit my property will become my relative and he also will be covered under the provisions of this particular act. Next, the term maintenance. What does maintenance mean? Maintenance means food, clothing, residence, medical attendance and treatment. So these 5 things are considered as the maintenance. Next, we will see who's a minor and who's a senior citizen. A minor who has not attained the age of majority, that is age of 18 years, and senior citizen is a person who is above the age of 60. So these 6 definitions form the key terms of this enactment, and the understanding of these 6 terms help the better understanding of the provisions of this act. Who is eligible to claim for maintenance? Senior citizen and parents, they are eligible to claim maintenance under the provisions of this act. So any senior citizen or any parent can file an application for maintenance from their children or relative by invoking the provisions of this act. Against whom it can be filed? Yes, it can be filed against the children who are not minor and against the relative. As I said earlier, the children means the grandparents, son, daughter, grandson and granddaughter, and whereas the relative means the legal heir who is going to succeed your property or who is going to inherit your property. Who can apply for maintenance? Yes, senior citizen, parent, person authorized or suo motu action by the tribunal. Okay, so the senior person can file, or the parents, they can file the application in person, or they can authorize any third person to file the application on their behalf. This provision is introduced because if any senior citizen is going to file, then he is not keeping well, he has to move to and forth. So to avoid all those things, the authorized person is given the right to appear before the tribunal on behalf of the senior citizen. Next, we have what is the procedure of hearing. Yes, the tribunal constituted under this enactment has the same power as that of the civil court. So as a civil court, they can send notice to the respondent and they can ask for the and they can ask the person to appear before the court, before the tribunal in person, and submit his statement. So once this, after the recording of the statements, after hearing both the parties, the tribunal shall pass the order. Can ex parte order be passed? Yes, an ex parte order can be passed if the tribunal is satisfied that the respondent is willfully neglecting to attend the tribunal or is willfully refusing to receive the summons. If the tribunal is satisfied up to this matter, then they can pass the ex parte order. Ex parte order, for those who are not from the law background, it means that passing the order in the absence of the other party. The natural justice law says that you have to hear both the parties before passing an order or before giving a judgment. But in case of ex parte order, the other party will not be present. Without hearing the other party, the order can be passed. Next, what is the time limit for disposal of the case? Yes, within 90 days of service of notice to the respondent, the tribunal has to dispose of the case. And it has the right to extend the date by 30 days by mentioning the reasons in writing. Suppose if there is like, if the petitioner himself or the applicant himself is not able to present before the court, or if there is any incident which happens, for example, lockdown, or the courts, the tribunals are not functioning, or the person who is the chair of the tribunal is not there, under those circumstances, they can extend the time up to 30 days by recording the reasons in writing. What if the order of the tribunal is not complied? If the respondents fail to pay maintenance, then the application has to be made to the tribunal within 3 months of the non-payment. When under those circumstances, the tribunal shall issue a warrant and ask the respondent to make the payment. In case if he fails to make the payment, then he can be imprisoned up to 1 month, and he can be imprisoned till he makes the payment. Yes, and now, what is the jurisdiction for filing of the cases? The jurisdiction is covered under Section 6 of the Act, which says that it can be filed where the applicant resides, or he last resided, or where the children or relative resides. So these four terms, these four jurisdictions can be ascertained. Can interim relief be granted under this Act? Yes, interim maintenance can be granted in a month of monthly allowance, that is in the form of maintenance to the applicant. So interim relief means the temporary relief, which is not the final order, but which is in between the court proceedings. Is there any chance of appeal? Yes. Appellant tribunal is constituted under this Act, wherein the applicant can go for the appeal. The major twist in this Act is that only the senior citizen or the parent, that is the applicant in the said case, can file an appeal under this Act. The respondent has no right of appeal in this certain case. And yes, they can move to the High Court in the form of writ or special leave petition or any other provisions wherein they can question the act of the law. They can issue a writ of co-warrant or something like that, but they don't have any authority to go for the appeal. Who can file an appeal? Yeah, as I said, only the senior citizen or the parent who is aggrieved by the order passed by the tribunal can file an appeal within 60 days of passing of the order. However, if there is any delay, then the reasonable grounds has to be explained, and then he can file the appeal by condoning the delay. Whereas the respondent has no right to go for the appeal. The appeal has to be dismissed or disposed of within 30 days of filing the appeal, filing the application. The appellant tribunal has to make it mandatory that the appeal will be dismissed off within 30 working days. Yes. Can a legal practitioner represent any party? No party proceeding before the tribunal has a right, or the appellate tribunal shall be represented by a legal practitioner. For this case, for this circumstances, a maintenance officer is appointed by the state government who can aid the senior citizen or parent. However, the Advocates of 1961 Act comes into role here, and the Section 30, it overrides this section, and it states that yes, the advocate can appear before the court. This was even upheld in one of the judgments, which we'll be studying in the further stage. 8. This enactment, it mandates every state government to establish the old age homes which can accommodate up to 150 seniors. Medical care for senior citizens. Again, it is a duty of the state government to ensure that the senior citizens are given adequate beds and they are being provided with separate queue facilities. Either it may be in the hospital, or it may be in a medical shop, or it may be any other places. They are being given separate queue facility for treatment and other medical privileges. This act also brings up certain funds which are allocated for finding out generic medicines for the treatment of the senior citizens. Section 23, that is void transfer. This is the heart and soul of the particular act. This section states that if a senior citizen transfers his property after the commencement of this act to his children, then the children are bound to take care of him, that is, provide him all the basic facilities. In case if the transferee fails to do that, then the said transfer shall be considered as void and shall be deemed to be made under fraud, caution, and undue influence. The tribunal has all the right to declare such transfer, that is such a property transaction, either it may be movable, immovable, tangible, intangible, any kind of property transaction, as void. The senior citizen who has made the transfer, that is the transferor, will get the property back. And as it is seen in this enactment, it is not necessary that a clause with this regard has to be made in the transfer deed or gift deed or any other deed for that matter. That only the love and affection has to be considered. Not necessarily it has to be mentioned that I am giving you this property, that means you have to take care of me. All these things, that is not necessary. It is only necessary that it has to be made out of sheer love and affection. Offences under this act. Exposure and abandonment of senior citizen is an offense under this act. If a person who is bound to take care and protect any senior citizen voluntarily abandons him, then he is punishable up to 3 months of imprisonment or fine up to 5,000 rupees. It is a cognizable and it is a bailable offense. Next, we have bar and jurisdiction of civil courts. Civil courts is barred from trying cases wherever this act applies, or grant any kind of injunction or do any kind of act under this act. Yes, we will look into some case studies, some circumstantial case studies. So here it is, my children staying abroad, and how can I serve summons to them? Yes, if the children staying abroad, then the tribunal shall send the summons, and from those appropriate authority, the summons will be served to the children who are staying in the abroad. And once the summons is served, then the children are mandated to appear before the court. And if they don't appear before the tribunal, then it shall be considered ex parte order can also be passed. I transferred all my property to the name of my son who resides in Pune. Later, he abandoned me. Now I reside with my daughter in Shimla, and I am aged 85 years old, and I cannot travel frequent. So can I file an application in Shimla? Yes, under the provision of Section 6, he can file an application in the Shimla. Section 6 reads as jurisdiction and procedure. The proceedings under Section 5 may be taken against any children or relative in any district where he resides or last resided, or where the children or relative reside. Again, the application is subject to maintainability by the tribunal. Next, we'll see some of the important case laws. The first important case law that we are going to see today is Paramjit Kumar Saroya versus Union of India. So in this case, what happened was like proceedings before the tribunal or appellate tribunal can be represented by a legal petitioner. Here, the Section 30 of Advocates Act 1961 comes into role, which I have mentioned earlier. The Section 30 of Advocates Act 1961 was not brought into force. It was not notified earlier. This was notified on 15th June of 2011. That is like almost after 50 years of passing the Advocates Act of 1961. It states that all the advocates have the right to practice in all courts, including the Supreme Court, before any tribunal or person legally authorized to take evidence, and before any other authority or person whom such advocate is entitled to practice. Next case is Radhamani and others versus State of Kerala. In this case, it was held that the welfare tribunal, it revoked the transfer of the property which was made by the father to his son. So this was questioned by the son in the High Court, stating that there was no specific mention which was made with this effect that the person will be taken care by the transferee, that is the father will be taken care by his son. But the Kerala High Court held that there is no requirement under law that there should be a written stipulation in the deed to that effect that the transferee would maintain the transferor. Even in the absence of this, the section 23 of the Act shall be applied. Okay, so again, this case stated that it is merely the love and affection which comes into role, not the clauses or not the express stating of the same. Next, we have Arshaya Gulati through her next friend Divya Gulati and others versus government of NCT, Delhi and others. So in this, the petition seeking to quash the rule 22 subclause 3 and 22 subclause 4 of the Delhi Maintenance and Welfare of Parents and Citizens Rule 2016 was challenged. It stated that it is ultra virus the act, and also it is against the provisions of Constitution of India. But it stated that but the High Court held that both the rules are consistent with the law and they are not unconstitutional. In this case, what happened was like the tribunal asked the persons to vacate or to evict the house which was given by her father to her. Okay, she was not taking care of her father. That is why her father filed an application in the tribunal and asked for that house back. And the maintenance tribunal said that yes, he is entitled to get his house back. And the eviction order was passed against the legal heirs. Henceforth, she had filed an application in the High Court questioning the constitutionality of the said provisions with the rules 22 subclause 3 and 22 subclause 4. This is all about the current act. Now we have this the Maintenance and Welfare of Parents and Senior Citizens Amendment Bill of 2019, which is passed in the cabinet and now it is pending before the standing committee for its review. Hopefully we will be getting this new act very soon. So we'll look into some of the important aspects or important changes which this law is going to make. The first thing is like it is going to broaden the definition of the term children, and it is going to include adoptive child, stepchild, daughter-in-law, son-in-law, legal guardian of the minor child. So all these people will be brought under the definition of the term children. Next, it speaks of the maintenance. As we have seen, the term maintenance, it includes only around 4 to 5 terms. But this enactment, this amended bill, it is going to increase the definition or increase the vastness of the maintenance by including the term live with dignity. Okay, so this will be covering all the aspects, like not only the medical treatment or food or healthy or anything, it also will include any other facilities. Next, establishment of multi-service daycare center for senior citizens. Yes, this amendment bill proposes to establish multi-service daycare center, which will be exclusively for senior citizens, and it will be made at the district level. So every district will have a multi-service daycare center where the senior citizens will get all kind of assistance. It may be medical assistance, or it may be some psychological assistance, or it may be like if they are sitting in the house, they want to do some service to the society, or they cannot kill the time. So under those circumstances, a kind of recreational center shall be created for the senior citizens, and that shall be named as multi-service daycare center. Coming to the next point, it is cases filed by the senior citizens who are above the age of 80 years should be disposed within 60 days. For the other people, we have the time limit of 90 days. Referral of the cases for the conciliation officer. In the current act, we don't have any facility of the conciliation or mediation. But the new amendment bill, it brings up for the conciliation officer, wherein the conciliation of the cases, the application filed shall be referred for the conciliation officer established under this act, and the conciliation officer is supposed to give a report within 15 working days. The current act, what we have, it says that 10,000 rupees is the upper cap of the maintenance. The tribunal has no right to grant maintenance amount more than 10,000 rupees. And this amendment bill, it plans to remove the upper cap of the maintenance limit and state that the maintenance amount shall be granted considering the standard of living and income of the senior citizen, parent, children, or relative. So based on their economic and financial strata, the maintenance amount shall be granted. Digital sharing of the maintenance order passed by the tribunal. Yes, this amendment bill is going to give some more of the digital touch to the particular maintenance tribunal or the senior citizens. So it is going to do everything e-filing, and all the orders that shall be passed by the maintenance tribunal will be available through the website or through the any other portals. And yes, the current act, it says that the maintenance amount need to be paid within 3 months. So this amendment bill makes it cuts it off to 15 days. So within 15 days of passing of the order, the respondent, he is supposed to pay the maintenance amount. If not paid, then again the warrant will be issued. Introducing home care services to senior citizens. Yes, the senior citizens are not able to travel, and it is difficult for them to move from one place to another place. And henceforth, the government has made this home care services, wherein they will be getting the medicines or any other essential basic facilities what they need through government by this home care services. All the services will be provided at their doorsteps, and they need not travel in and around. Establishment of special police unit at district level for the welfare of the senior citizens. Yes, the special police unit shall be established at the district level, which will be exclusively dealing with the issues related to the senior citizens. Any complaint which is received by a senior citizen, or if any senior citizen is found roaming in and around all alone without any guardian, or if he is found sleeping on the street, under those circumstances, the police the special unit of police, they have the special power to take suo motu actions and get them back to their home, or admit them to any old age home which is established by the government. Abandonment of senior citizen to be replaced with abandonment of the senior citizen and parents. The current act, what we are having right now, it deals only with the abandonment of the senior citizen. That is, you leave your parents somewhere in the bus stand or something like that. But this amendment bill, it also includes the term parents as well. So abandonment of the senior citizen as well as parents is an punishable offense under the new amendment bill. Penal clauses for the same is increased up to 6 months and imprisonment of 10,000 along with fine. Yes, the current enactment, it penalizes the offense for 3 months of imprisonment and 5,000 rupees fine. Whereas this new amendment bill proposes to make it up to 6 months and 10,000 rupees as fine. Right to appeal to be extended to children and relative as well. As we have, as I mentioned earlier, the right to appeal was only with the parent, was only with the applicant, that is either senior citizen or parent, whoever it may be. This shall be extended to the children and to the relative as well. So both the parties shall have the right to appeal. They can appeal in the appellate tribunal. So this is all about the maintenance and welfare of the seniors, parents and senior citizens amendment bill of 2019. As I said, this is approved by the cabinet, and this is for the review with the standing committee. We are hoping that this enactment will be brought into force by this year end, or at the earliest of the next year by 2022 or something like that.